everybody, can everybody hear me?
Yes.
All right. Yeah, okay. I like yelling. I'd rather not use the mic, but I think it will probably be good for everybody sitting in the back. All right. So good afternoon. My name is Blake Hampton. Thank you guys for coming today. Thank you to Goodwill and Jessica for putting this seminar on, and Hodges for hosting. And I am an estate and elder law attorney, and also special needs planning attorney. I've had my own practice since 2015. And I'd say most importantly, I'm also a sibling of an individual with special needs. I don't like to use the word intellectual disability or the word disability at all. I think that in the context of planning, special needs is I think just a better term. So that's the term that I'm going to use throughout this presentation. So let's see. All right. So I'm going to start with turning 18. When you have a child with special needs that turns 18, a lot of things change. And one of them is they're legally an adult. They can make their own decisions. And you can't sign on their behalf anymore. They can still be in school, but they are held accountable for their own actions. So I'm going to address that issue in this presentation as well. Also, when someone turns 18, they typically become eligible for SSI and Medicaid. Once someone is a minor, when a child is a minor and they have special needs, it's very hard to get SSI because they look at your income, your assets, and when the child turns 18, for SSI purposes, that goes away. And I'll explain more about what SSI is later in the presentation. All right, so primarily today I'm going to focus on estate planning. I am an estate planner, a proactive planner, with a heavy emphasis on proactive incapacity planning and special needs planning. So dealing with individuals who may need long-term care or independent planning. Decision-making, that is going to address guardianship, guardian advocacy, and also this new supported decision-making, which is a trend in other states. New York probably is one of them that always been on the forefront of special needs planning as an alternative to guardianship. So I'll start in that part of the presentation with supported decision-making. Public benefits. I could speak for probably about 6 hours on Medicaid, maybe more. It's about 40% of my practice is dealing with seniors and Medicaid. And I'm not really going to get into financial planning, but that does kind of complete the spectrum of planning for for your child. All right, so we're going to start with estate planning. So I look at estate planning as life and death. It's not just where do you want your money to go when you die. It's what happens if I can't make decisions for myself. Durable power of attorney. That is the legal document that allows somebody else to make decisions on your behalf. Healthcare surrogate. Some states they call it medical proxy, medical power of attorney, healthcare power of attorney. I think every state has its own term for the same word, and that's somebody that you've delegated healthcare decision making to. Living will, I'm not going to get into very much, but end of life planning is important. Living will is, I say, it's the pull the plug document. It's two physicians certify that you are terminal, end stage. In layman's terms, the lights are on, but no one's home and no one's coming home. Terry Schiavo. Pre-need guardian, that's a very important, important document. If a guardianship proceeding was initiated against you, so guardian, and I'll explain what guardianship is in a minute. You're telling the court who you want to be your guardian if a guardianship proceeding was initiated. You can file a form for a minor child as well. So if you have a minor child, you can file that for free, the declaration of pre-need guardian for a minor with the court. And if a proceeding was even initiated on you, the clerk is commanded to tie in both guardianships, try to keep the family as intact as possible. Healthcare surrogate for a minor, also important if you're out of town and you have a minor child who's, back in the day, my grandmother probably could have taken us to the children's clinic, and they knew my aunt, they knew my cousins, they knew all of us. And it was just, oh, sure. Nowadays, it's not the case. If you're going out of town, and it's just a good idea to have this healthcare surrogate for a minor if you have minor children. The big ones now, the death side, last will and testament. Probably the most overrated document in the lot, because it's a probate document. I don't know if anybody knows what probate is here. It's usually just associated with bad. It's not. It's a court process for certain assets that are subject to probate, and it's a court supervised process to make sure your assets go where they're supposed to go. It's a public process. Anybody can go down to the courthouse and get a copy of your will once it's filed, and an inventory, know what was in your estate, your probate estate, that is. How do we avoid probate? We use revocable living trust, typically. It's a trust that you can amend or revoke during your lifetime. And I'm going to get into what a trust is in my next slide, so I'm going to stop there. If your child, when they become an adult, can make decisions for, or at least some decisions for him or herself, they should probably have estate planning documents as well. Will, power of attorney, healthcare surrogate, the whole lot of documents. Power of attorney, in particular, is a much more affordable document to have drafted and execute than a guardianship or a guardian advocacy proceeding. Not to mention the courts, and this is becoming more and more of a thing with decision making. Guardianship is a last resort. We're always supposed to go with the least restrictive approach and addressing individuals who may have some diminished capacity.
I have a quick question. Does the durable power of attorney stop once the person passes?
Absolutely.
Okay, I think that's a misconception.
That is a big misconception. Actually, thank you. When I have client consultations, I draft a little chart where I have life, death, power of attorney, healthcare surrogate, living will, and I then draw arrows to that dividing line to death, and I X them out. I'm like, nope, nope, nope. They're not good at that point. So thank you for for adding that. But trusts do survive you. That's with a living trust, or revocable trust that you create during your lifetime. When you pass away, that trust can survive you. Things will change, but all right. So what is a trust? Trust. I'm gonna take a sip of water real quick. A trust is, I like to explain it and think about it first like a business. It's its own entity apart from you. It has, instead of a CEO or director, we have a trustee. We have accounts, just like in a business where they're owned by the business, and you write checks and it says the business, and who's authorized to write those checks. Same thing with a trust. The trustee's name will always be on the check with the trust. Difference between businesses and trust are Businesses, you have corporate filings, annual reports. You can see who the members of an LLC are online. They have a business purpose and they really continue on in perpetuity. A trust has a trust purpose and beneficiaries. So the trust has to have property or has to own something for it to be. It's just a piece of paper if it doesn't own anything. There's no magic wand. I think the only state that has a quote magic wand provision is California, where things just miraculously end up in the trust on its own. I don't really understand that, but so the last aspect of trust that I want to get into before I get into special needs trust are that attorneys like to use the term inter vivos trust or testamentary trust. I don't really like the law school terms. I prefer to use the term living trust. That means you created it during your lifetime. Testamentary trust means it was created pursuant to your will. So that trust isn't active now. It doesn't own anything. It can't own anything until it's established upon your demise. And there are more flavors of special needs trust than the two primary ones up here, but this is where I find the most confusion. A first-party special needs trust and the word special needs trust imply something very different to the Social Security Administration and Department of Children and Families that review financial eligibility than a supplemental needs trust. Special needs trust, again, can be created, it's a self-settled trust. That means the individual with a disability or their parent or power of attorney or a court can establish on their behalf the first-party trust. Most of the time that has to do with personal injury settlements, or if somebody's inheriting money and they didn't do proper planning, their parents didn't leave the assets in a supplemental needs trust, and now we have to get a court order to place the assets in a special needs trust. The downside to a special needs trust is, well, one, it's irrevocable, it has to be. Then the child cannot be trustee. You as a parent could be trustee. And the big one is it has a payback provision to the state. So when anybody has been on Medicaid during their lifetime, the state has a Medicaid estate recovery unit. And there's a Medicaid lien. I don't like to say Medicaid is like a lifetime loan, but in some ways it kind of is. And this type of trust has to be filed with the recovery unit, and they receive what's left over up to the amount of the lien. So you don't really want to put a lot of money. This isn't a planning tool. This is one you really want to try to stay away from, in all honesty. But sometimes you can't avoid it. Third party, supplemental needs trust. This is the big one. This is like the linchpin of estate planning when you have a family member or a loved one who has special needs. It can be created, and it can't be created by the person, unlike the trust I just spoke about. It has to be created by somebody else, a third party. Typically it's a parent, but again, I could be the trust creator, or as the banks call it, a grantor for my brother's trust. I think I may have been on one of them. You got to be careful too. If you're trustee and the grantor, sometimes IRS rules get complex with taxing trusts. Sometimes you can end up being the one taxed instead of the beneficiary. So careful drafting and consideration needs to be taken into account when drafting a special needs trust. It can be revocable or irrevocable. So revocable means you can revoke it, you can amend it, you can change it. Irrevocable is, well, attorneys are going to tell you no trust is truly irrevocable. You can go to court and modify it. There are ways to add flexibility into an irrevocable trust, and I'll explain what that is in a minute. Revocable trust, a revocable supplemental needs trust, though, typically becomes irrevocable upon a certain event. Either it receives money. A lot of times, it's a perfect planning device for a working person who has not much of a nest egg, and they fund it with life insurance. So if you are insurable, you can get life insurance, you name the trust as a beneficiary, and when you pass, once the trust receives a dollar amount over whatever minimum you put in place, the trust becomes irrevocable at that point in time. And at that point in time, it's also going to need its own tax ID. There's no payback provision in this type of trust. That's the beauty of it. It's for people who are planning ahead. Hypothetically, I have $100,000. Wish I did. But if I did, and I was leaving it to my brother, I would name the trust as a beneficiary and not him. That's the beauty of having a trust that's created now versus you can create this type of trust in your will, but other people can't fund it. What if you have a generous uncle that has no kids who wants to leave money to his favorite nephew with special needs? This is the device to do it. It can receive money now. It's more flexible, and that just has a lot of benefit to it. All right, let's see what else we got here. All right. Created by parent, a child is a beneficiary. Your child cannot be the trustee of his own supplemental needs trust. So if he can make some decisions for him or herself, that's not possible. There are certain restrictions in a trustee's ability to distribute funds, and I could spend a whole hour on what a supplemental needs trust can spend money on. The more blanket answer is, you can't pay for something Medicaid is paying for, or you can't, duplicative or redundant, I can't remember what the term is, but you can't pay for something that Medicaid's paying for. That's the bottom line. One of the big ones, Medicaid dental care is not always it's not always great, if you will. So one of the big common things, services that a supplemental needs trust pays for is dental care. Upon the beneficiary, the child's death, the trust can name beneficiaries. You could go back into the rest of your estate plan. It could go to siblings. It could, whatever the case may be, you can draft it so it still has an additional estate planning feature to it. One way we address, and I don't have it in a slide, when a trust becomes irrevocable, one of the big questions is, what happens if I need to change the trust? Well, this is where the irrevocable trust is never truly irrevocable. We use what are called trust protectors. Trust protectors are a third party. Typically, you have an attorney like myself who is the designator. I can designate the trust protector. So family says, we need to make a change. I'm going through a divorce. I can't handle my brother's trust anymore. Like, sister's going to do it now. Sister steps up. All right, the trust protector can help make that switch. Also, the trust protector can deal with tax law changes and a whole bunch of other issues that could arise. All right, so flexibility, I think that's the big one with this type of trust. A separate supplemental needs trust has flexibility. And it can be revocable, then it can be irrevocable. We can have a trust protector. We can, and life changes, so it's very hard to draft. You don't want to draft a very tight trust that can't be amended or changed because you don't know what life, none of us have a crystal ball. If I did, I would go play the lottery right now. The trust can, again, receive funds from any relative, or anyone for that matter. And if you have to make a change to that trust, you don't have to amend your entire estate plan. So if you have a big trust with 4 other kids and this, that, and the other, and you need to make a change just to your son or daughter with special needs trust, you can do it separately. It doesn't have to interfere with the rest of your estate plan. So what does and anytime you see the word S&T in estate planning, usually it's lawyers, we like to abbreviate, ACA, DCF. SNT or S&T it stands for Supplemental Needs Trust. So it could own real estate, could own vehicle, investment accounts, cash, and I have life insurance in bold, and I did that for a reason, because for working folks, one of the best ways to fund one of these trusts is if you don't have any money, you think, why would I need this type of trust? Well, if you can afford life insurance and you're insurable, that's a great way to fund the trust. What do you not put in a supplemental needs trust? I'm glad I'm not talking over the AC now. You don't put qualified retirement accounts or non-qualified retirement accounts in there. So 401ks, IRAs, 403bs, 401as, 457s, any one of those accounts that starts with like 3 numbers. So here's another one of these like elephant in the room slides. ABLE accounts. You asked me about ABLE accounts not all that long ago. Should we have an ABLE account? How do they interact with trust? So I'm going to get into what an ABLE account is. An ABLE account, in the context of everything, is its own separate account that you or your child could establish through the state of Florida. It's called, our ABLE organization is called ABLE United. You don't have to use them, but I think they're really good. I think they explain things. They have good tutorials. They made it incredibly user-friendly. I wish the government sites worked as well as ABLE United did, because it would really, I wouldn't have a job. So if you ever heard of a 529 account, this is a 529 capital A account. It operates very much like a 529 account. And let's see. So ours is ABLE United. You can give up to $17,000 per year. If your child is working, they can put additional funds in there. Although I don't know in reading the rules, I don't see a bright line limit on how much a working person can contribute of their own money, but if somebody was working too much, they wouldn't even be eligible for any public benefits anyway. So the money that you put in there can accumulate, and it's not considered a resource for asset limit public benefits or means tested public benefits. So Medicaid, you can only have so much money. SSI, you can only have so much money. The money that accumulates in the ABLE account up to $100,000 will not impact public benefits. That's a big one.
Is it interest bearing?
There's several investment options, and I'm sure they're all very conservative, just because that's the nature of this type of planning. Qualified expenses. There's a whole laundry list of what an ABLE account can pay for, and they're all on the ABLE United website. That website address is in your resource, like my little helpful resource handout. And they have videos, that's one reason I'm just doing one slide on ABLE accounts, because ABLE United is a fantastic website. I know some of the attorneys that work with the state on the site, and they did a very good job. There's no payback provision with this type of account. That was one of the reasons a lot of attorneys were not too comfortable using them. We didn't know if Medicaid was going to look for payback when the individual passes away. And we can confirm, the government has confirmed in writing that no, there is no payback provision in this type of trust. This type of account, I'm sorry. This type of account, one of the big benefits of an ABLE account is housing expenses, and a trust can even fund an ABLE account. And if the ABLE account is paying for the housing expenses, if it's done right, you can prevent a reduction in the SSI benefits. Because if anybody has a child living at home with them and on SSI, they know that you probably are getting $400 or $500, not the $900. That is a in-kind support and maintenance reduction. And with careful planning, you can avoid that. So now I'm going to get on to decision making, and I'm going somewhere with this. It's going to be guardianship, but before, if someone comes to me, the first thing they ask is, I think my son, I need to be his guardian advocate because he's got it. Well, can he make? First thing I'm going to ask them is, can he make or can she make decisions for herself, and what decisions are those? Because guardianship or guardian advocacy is a last resort. So we don't want to, unless we need to, we shouldn't use it. And the difference between a power of attorney, which is a delegation of your authority, and a guardianship, which is an assignment, which is the court taking away your rights and giving them to somebody else. Very, very different scenarios there. So supported decision making, it's very new in the state of Florida. We don't have a law backing it up, but turning18.org is a very useful website, and I still think everybody should go look at it if their loved one is in that realm where they can make some decisions, but maybe not all decisions. They have a electronically tutorial, and you can answer the questions, and it really helps walk you through it. And the idea is that that the disability advocates are promoting supportive decision making as an alternative to guardianship, because guardianship is it's a very invasive process where, God bless the court, they're great, but I know personally, nobody wants the court in your business if you don't have to have them in your business. So supportive decision making is an alternative to the court. So now we're going to get on to guardian advocacy. Before I get into guardian advocacy, I want to say briefly what a guardian is and why is it different than a guardian advocate. And also the word conservator comes up, especially if you're from another state, which just about everybody in Florida is from another state. The word conservator in most states means guardian of the property. In Florida, you have guardian of the person and you have guardian of the property. A conservator is actually appointed by the court for a missing person's assets. So if somebody goes like MIA, a lot of times it's service personnel, military service personnel. That's what conservatorship is in Florida. Think missing person, not just guardian of property on behalf of somebody. It's on behalf of a missing person. So that process is not the process you want to use if your child has developmental disabilities. That's a term that the court uses for guardian advocacy and how we get there versus guardianship. Guardianship, you file 2 petitions, 2 filing fees, a court-appointed attorney, 3 examining committee members, and all 4 of those people, they're all getting paid. And who do you think is paying them? Not the state. So it's expensive. And then there's a hearing. And after all those reports are filed, the hearing is on both determination of incapacity and the appointment of a guardian. It's a much more extensive process than guardian advocacy, where if somebody was developmentally disabled before the age of 26, I believe, or no, you know what, it might actually be 18. 26 is able accounts. We don't have to go through that process of filing the petition to determine incapacity. What you want is the IE. I'm gonna get a sip of water. And the IEP, or a physician evaluation, it proves that they were developmentally disabled before the age of 18. Again, one of the packets I brought today is guardian advocacy. Because guardian advocacy, if it's just of the person and not the property, you don't need an attorney. And we don't have to go through all the examining committee members, and it's just the IEP, one petition to appoint guardian advocate of the person. It's a much easier, smoother process than full-blown guardianship. If you have property added in there, then guardian advocate of the property, you open up a whole new can of worms with accountings and inventory of assets, and if there's a special needs trust, the court wants all that information as well. They're trying to make sure that there's a lot of fraud, there's a lot of theft of assets from people that are elderly or have special needs. So the court's really trying to make sure that their money isn't going to somebody's gambling habit or all sorts of crazy stories you can hear from the court auditors. Yes?
Is it the parent's assets or the child? I have an adult child that has assets.
The child has assets and they cannot make financial decisions
Right.
for him or herself, guardian advocate of the property would be a wise idea in addition to guardian of the person.
Okay. So it's they can have their own assets, they
Mhm.
can be managed, okay?
And what a lot of times we see, and one of the reasons you wouldn't need property is if you have a special needs trust or supplemental needs trust, and there's a trustee of that, probably the parent, then the individual doesn't have, quote, an estate inventory, so there's really no reason for property. If they have a checking account where you're representative payee for Social Security, the court says that that doesn't matter, you don't need guardian advocate of the property. Representative payee is a fiduciary role that only has to do with Social Security Administration, and so the courts kind of tiptoe around the feds. So you petition the court. Again, you can find those forms at the clerk of court's office. I put a link to the forms a web address in my handout, and even the guardianship clerk's phone number and extension if you need help completing those forms, and you can find them online as well. They're fillable. They did a very good job with them. So you file the petition, and the next thing that happens is the court appoints an attorney. They call it an elisor, and that attorney represents your child against you in some ways in this guardian advocacy process. But it's actually much more friendly than that. The court-appointed attorney for, I'd say, probably the last 10 years is Ryan O'Halloran. Roger O'Halloran is one of the deans and legends of special needs planning. His son has Down syndrome, and he told me this several years prior to even doing it. He said the next big thing is going to be restoration of rights and this supported decision making. 5 years later, I see something in the news about his son's rights and being restored. I mean, he had matured to be able to make more decisions by the age of about 44, but that's pretty impressive. So he's a good court-appointed attorney. We've dealt with him in our own house, and I think my brother liked him a lot. He's really nice, he's got a good demeanor, and it's not an adversarial process. Then you have a court hearing. So then the next thing that happens after the court contacts you and tells you there's a court-appointed attorney is you have a hearing, and the hearing, typically the court-appointed attorney will show up to the hearing, your attorney, if any, and you will show up to the hearing. You're welcome to bring your child. I think it's a good idea, in all honesty, and it's kind of fun on the day in the courthouse. Once the judge or the magistrate grants the order, it's called what are called letters of guardian advocacy or letters of guardianship, and that's like your holy grail that you can take to the bank and say, my son has an investment account, and the court's determined that he doesn't have capacity. Here's the letters of guardianship. You can take control. They can't say no, and you have the power of the judge's signature behind your letter. So if a bank refuses, we can get the court involved. So they typically don't have a problem with it. The next big thing in guardian advocacy that I want everybody to know is that it's not done yet. This is an ongoing process throughout the lifetime of your child. Within the first 60 days, you want to file an inventory or you get a nasty gram in the mail. I've gotten a few myself. So it's a very intimidating letter. It's really not that bad if you were to forget to file the inventory being what the individual owns. You call the auditor, they're really, really nice. And then you file an annual plan as well, or initial plan. So you get the initial inventory and initial plan, and then every year you have to file an annual accounting if there's property, and an annual plan and physician report as well.
Is that a local level or state level?
State. So that is a function of the circuit court. If it's Lee County, it's the Lee County. It's a 20th Circuit in Lee County, Florida. So if it's in Collier County, it'd be called 20th Circuit in Collier, and every one of the county clerks and every circuit has, except for Hendry. Some of the middle of the state counties don't have good help sheets and forms, but most of them do have good self-help forms.
So our tax dollars is funding that department that felt that.
Yes, in addition to inventory fees, if you have a big inventory that's being filed, the fee can go up based on the inventory. I don't think that's a real profitable endeavor for the courts. I think it just helps cover some of the auditing costs, because they do look at everything. They look at what you report, and then the financial statements behind it, and everything has to reconcile. So but it's not that bad. Beyond annual accountings and annual reports or plans, the next phase of life is obviously death, or if somebody is growing, maturing, it's restoration of rights. So you always want to kind of keep that in the back of your head if your child is possibly in that realm. This doesn't necessarily have to be forever, and Ryan O'Halloran's brother has proven that to be true. All right, now I'm on to another, I guess, final big topic, and that's public benefits, which is huge. I could speak on each one of these benefits for probably about 6 hours or more. So I'll start with SSI. It is a means-tested benefit. That means it has financial requirements, income and asset requirements, and then there's also a medical requirement. So think of it like this: medical and money, 2 M's. SSDI is what most people will call Social Security disability. I have it on there for a very good reason, and I'm going to explain why in a minute. But it is a work-related benefit. It's not means-tested. Somebody can inherit $500,000. It does not matter. It's can you work or can you not work, except for the one exception I'm going to tell you about. And it's from personal experience, too. Medicaid. Medicaid's another one of those that's very confusing, because there is Medicaid, what we call community Medicaid, or Medicaid for the aged, blind, disabled. Then there's the Medicaid that you try to go through what will feel like a hopeless process with the Agency for Persons with Disability, APD, and that's the Developmental Disabilities Home and Community-Based Services Waiver, and the famous iBudget. I always forget why it's called iBudget. It's institutional, it's developmental disabilities, institutional budget waiver. That's the full term. That's a mouthful. And it just has all sorts of different services that it can pay for. For instance, going to Pathways is one of them. I'm on the board of LARC, and iBudget and Medicaid's a big part of our LARC budget, because we do have, we had 2 group homes. The hurricane took one, but we're going to rebuild somewhere else. But it helps with group homes and independent living. An alternative, and what the state's trying to push everybody towards, and they're test running this in I believe Miami, and it's going to be either really good or really bad, is trying to push more home and community-based services individuals onto the standard Medicaid managed care long-term care waiver, which means instead of having an APD social worker, you have a social worker assigned by one of the managed care organizations, and managed care is very complex. Again, I could talk for hours just on Medicaid managed care, and I help a lot of my seniors in particular go through that waiver process. Your child could potentially be eligible for that waiver though. So if your child needs long-term care services and you're hopelessly at the bottom of the wait list for APD, that isn't a potential alternative, and you go through the area agency on aging to initiate that process. And I have their contact or their website in my handout as well. Medicare, why would I talk about Medicare when most individuals are on Medicaid? Well, here's the scenario. When you retire, if your child was a dependent of yours and you're collecting Social Security, their SSI, if they have SSI, is now going to convert to SSDI. So they now are on Social Security disability, a non-means tested benefit based on their parents' work. And the increase in money can be significant. But your Medicaid is protected under what's called protected Medicaid. And then, just like anybody else who's on Social Security disability, they're eligible to early enroll in Medicare after 2 years of being on disability. And there are Medicare supplements for individuals with special needs. I believe that was thanks to the Affordable Care Act, which has been personally devastating for me as a small business owner, but I'm glad that it's helped cover a lot of folks that would otherwise not be covered, because it will cover some additional services that and healthcare services that Medicaid doesn't always cover or you're on a wait list for. So SSI, I believe, with inflation, they've been updating these numbers a lot more often, they being the government. The figures have been changed quite a bit thanks to inflation. Right now, the maximum SSI amount is $914 a month. I don't know anywhere in town that you could live, or anywhere in the state of Florida for that matter, maybe in the country, where $914 is going to pay for your living. It's unfortunately a very low, underfunded benefit. What makes matters worse with SSI is if your child is living with you, then you will probably end up with an automatic ISM reduction. So the first $20 is disregarded of the calculation of how much you get. The 20 first, and then that's of income, that is, anything you have coming in. Then from there, any support that you're receiving from your parents, if you're living with them and their overall cost of running the household is $3,000 a month, and it's just you and your son or you and your daughter, they're going to look at it like you got $1,500 in in-kind support and maintenance going to that child. Very complex, very confusing. I have a spreadsheet on how I run through the numbers to be able to project what somebody should be receiving. And it's even hard if you think your child should be receiving more money. It's really hard to even appeal. A lot of attorneys won't even take those appeals. I'm going to skip to what type of state. That has to do with 203B, some Social Security rules. I was like, that's too much of a lawyer slide or point. $2,000 in countable assets. This is very similar to Medicaid. When I say countable assets, that means Medicaid and SSI look at certain assets and count them towards that limit, and there are certain assets that are not counted towards that limit. Typically, IRAs, 401ks, your primary residence, vehicles, term life insurance, anything without a cash value is not countable for Medicaid purposes. Brokerage accounts, cash, third vehicles, second vehicles that are luxury vehicles. So yes, you could have a Ferrari and it would not be, if you have one car, it would not be countable. I don't recommend that unless you want to end up on an episode of 60 Minutes. And there's a 36-month look-back period. So when you apply for Medicaid, it's a 60-month or 5-year window, and for SSI, it's 36 months. And they're really looking at transfers of trust, or have you given anything away to qualify for Medicaid? Was 1993 was where you had bipartisan legislation. It's very dangerous when both parties actually get along. This is how we got all these complex rules. It started with the Omnibus Reconciliation Act of 1993, where they were balancing the budget. I think that's the last time Congress balanced the budget, and that's what gave us all of these complex Medicaid rules. So SSDI. Going to hit this briefly. Attorneys, we call it disabled adult child. I think the government even calls it that. And what that means is your child was a dependent, they're on SSI, then you retire and they're eligible for SSDI, and we call that a disabled adult child. It's what's in the provisions of the federal law. You can even be a step-parent. So if you have a step-parent that retires and they had a really good earnings record, well, if your child is a dependent of your spouse, it's a step-parent, that can happen. I've seen it from personal experience. And if you had the community Medicaid before that was tied to the SSI, because if you have SSI, I forgot to mention, you automatically should have community Medicaid. Those two are tethered. You don't even have an account with Department of Children and Families or ACA, the state Medicaid agencies. SSI and Social Security report that directly to those agencies, and you have community Medicaid as a result of the SSI. But if you have SSI and it converts to the SSDI, it's still protected, and we call it protected Medicaid. So those are the big, I call these the big Medicaid benefits. And just to review, you got community Medicaid, you have the home community-based services waivers, the long-term care waiver, which is obviously done through Elder Affairs and the Area Agency on Aging. Then you have the APD, Developmental Disabilities Waiver, which is more robust, but more underfunded and harder to get. And resources. One of the big things is also making sure if you can afford a financial advisor, having a financial advisor, having an accountant, having a team of people that know your family and your family situation is very important to planning. Because the hardest part is taking yourself out of the situation. How does your child function without you there? So it's like the question nobody wants to think about or answer, but you have to plan from that scenario onward, because we have seen individuals at LARC who have not planned, seniors that ended up having a fall and going to a nursing home, and we end up with a new group home resident and there was no planning done, and just it's sad and it's chaos. So start early and create a team of people around your child. So that's pretty much all I have. Does anybody have any questions? That always scares me. It means either did really good or really bad. So I would like to thank Goodwill and Pathway School for hosting me. And if you haven't grabbed handouts, we have handouts outside. And take my card, and if you want to do estate planning, we'd be happy to serve you. That's it.
I had questions,
Oh.
but I thought you were carrying on with.
Oh, I'm sorry. Okay, no,
presentation.
go for it. Perfect. I love questions.
So, I'm at the place where I have a will and a family trust, and I have an adult handicapped son that is living independently, and he has a home in his own name, it's in his name.
Mhm.
And I need, we already have like health care, you know.
Mhm.
The big thing everybody needs to know is just because you're your mom and they're 18, you know, that's a wake-up call. People aren't thinking that. They just think, I'm his mother, I can always do everything, and you can't.
No.
I had that happen last year. He went in the hospital, and, but trying to figure out it, when I pass, what I own then goes to my two children, and one would be my son. I don't want him to inherit, and then he can't qualify for his
Assistance.
assistance,
Mhm.
you know? So he needs the special needs trust, right? Like,
Mhm.
so it can flow from me to him. But was it going back to your, does he need the third party supplemental needs trust?
Correct. That would be the ideal way
Not
that
the
we.
first one you had.
Now, first one's, I only mention the first one just because people use the term special needs, and when you use the word special needs trust, it tells the government there's a payback provision in there. And
Okay.
that's really the only reason I wanted to differentiate the two, because they often are confused, and they're very different, serve very different purposes. But the supplemental needs trust could be created in your will, it could be created in your revocable trust, or it could be a separate trust on its own. I like that flexibility of having it as a separate document, because we could even do a directed trustee role, where if you have a financial advisor that knows the situation, you can have them as a directed investment trustee. They're not administrative, they don't have administrative liability, but so you keep the continuity. You can have an account as a designated representative, your CPA that knows the situation. So I have one client, she's a pilot, really cool human. Just amazing what she does on her own as a single parent. And her son has schizophrenia, and we've just drafted all this custom planning to try to put a team around him, but also with flexibility as well, because you don't know what life holds. So I just think it's smart and ideal to have it as a separate document.
But how do I have an alternate person, suppose I have everything set up, and something happens to me, then who could my daughter step in to be my son's without going to have this whole guardian thing?
If he can sign a power of attorney, I like to name more than one person on the document.
We have that.
So if he can sign it, he names you number one, he names daughter number two. Or sometimes I draft, when the whole family gets along and we're all on the same team, I like to draft mom, dad, brother, all with independent authority to act, whoever can step up to the plate today. That way you don't have to prove to a bank, like, if mom and son were in car accident, you don't have to prove all that to the bank to get a bill paid. You can just stroll right in, and the key word there is trust. Naming people, you need to name people you trust, and think through who you name in your own documents, and in any role taking care of your loved one.
But then what does your independent child that has assets, does he need to get his own trust?
No. And when
Because-
what a lot of times we'll do is we'll have.
I could be dead and gone, and he's on his own, what happens to his home, you know, like,
The hard part is always taxes, maintenance, upkeep, and if the supplemental needs trust owns the house and has its own cash account, and brother is trustee, brother can use the account to help pay for those bills. And again, there's a lot of ins and outs with public benefits and making sure that you don't lose them, but that's where, it's not just a matter of creating this trust. It's not this type of planning is not just a one-time deal. It's the devil is in the details and the ongoing administration of.
so the supplemental needs is not like my name for my son, it's my son's,
Mhm.
it's in his name.
Correct. It would be,
And I would it funnels over to him.
it'd be like the John Smith Jr. Supplemental Needs Trust.
And then that is managed by another outside person? Or
It
family?
could be you, and then you name daughter as
Yeah, but
a.
I'm dead, and, you know, I mean, like,
Correct, you'd be trustee while you're alive, and it's still revocable, but you pass away, it becomes irrevocable. Daughter steps up as the trustee, and that's why we draft that flexibility of having trust protectors in there's nobody that can serve in the role. The trust protector can help initiate the process to appoint a new trustee.
And how do we keep Social Security and all them people out of that?
They don't.
Because
they're-
isn't it an asset at that point?
Secret, from my government attorney friends, the government doesn't have any department that reviews those third-party trusts. I've tried to submit them before, and they're like, we don't have anybody that reviews them. I'm like, oh my gosh.
Because I wouldn't want my child not to be able to get his food stamps or whatever, because
Correct.
he's got this money over here, he can't access it, but.
That's why we use the supplemental needs trust. It's not even reported. It's your money that goes, or third party's money, not his own money that goes in there. So it's not something that he's having to report as a transfer from him to a trust. It's something that happens outside of their view. It's nothing nefarious. It's just smart planning. They know it. We are allowed to do it. They actually make special provision. Like the rules specifically say you can do that. Now, if you run into a conundrum where you have money coming in, say from a personal injury settlement or something, he's in a car accident, that's when that other type of trust comes into play. You can't throw that type of money, his money, in a third-party trust. Only third-party money can go in a third-party trust.
But that also could be protected, let's say, a settlement from a car accident,
Mhm.
could that be protected from, and still he can have his Medicaid,
Absolutely.
Okay.
That's what I do that for personal injury attorneys. That's it's settlement planning. So anytime they're at the end of a lawsuit, they're like, all right, this person has certain needs, and then I get the call, special needs trust, and I step in to take that liability and weight off of that attorney's shoulders, and I in fact have a more ongoing relationship with the individual at that point than even the personal injury attorney in those types of cases. And that's another reason I put it in the slide, because it is important to know. As this billboard say, accidents do happen. So, especially on these roads. So I guess with the supplemental needs trust, typical plan, ideal estate plan is a master revocable trust. Say you hypothetically have 2 children, one that has no special needs, just, I don't even want to use the word normal, but an adult child who's working independent, not a problem, one with unique challenges. Having a separate supplemental needs trust there, you have your master trust, money could continue on for that child, so you can, it just, to me, it plans, it's not to have more trust, there's more flexibility than having it built into the main revocable trust.
That makes sense.
But it doesn't mean you're out of, like, it's horrible or all bad, it's just what's more ideal.
How about this, so supposing that this thing didn't get set up, this supplemental needs, so you just have a regular family trust, and something happens to me, and my kids are supposed to get it 50-50, can you have, at that point, have that supplemental needs trust set up before he gets the money?
Correct,
Okay.
absolutely.
So that's your get out of jail card if you didn't do your stuff.
It is, absolutely. Yeah, every estate plan I do, every will and trust, unless the person is alone and only naming charities, sometimes you get people like that, and I commend them a lot because charities get a lot of money for that. But a contingent a supplemental needs trust, that means contingent upon somebody being disabled that you don't know. So say a child predeceases you, and now his children are going to inherit his share of money, and one of them has some unique needs. Well, we have contingent minors trust provisions and contingent supplemental needs trust provisions that kick in, so it's not like all is lost. Again, it also helps avoid needing additional court involvement and supervision. I call trust privacy protection. They're very private. There's no state registry for the trust, so they're wonderful devices if they're when they're needed. Any other questions? No? Thank you very much. It's fun.
Very, very friendly.
Yes, thank you everyone for coming. If you need information on how to apply for your